My client was a Bronx electrician who was injured in an accident in Westchester County. He was working at the construction of a hotel performing electrical work when he fell from a 10-foot A-frame ladder. Hi, I'm Joseph Donahue and I'm a partner at Block O'Toole and Murphy. My client injured his neck and his back and his left shoulder. While he was able to leave the work site that day on his own, eventually he required medical treatment due to the pain he was having. During the course of his treatment, it was determined that he suffered a tear in his left shoulder that required surgery. He also had injuries to his neck and back that required pain management, including various injections to both his cervical spine and his lumbar spine. The injuries that my client sustained had a significant impact on his life. He was a father of 5 children, some of which were already in college. And because of the accident, initially he was not able to return to work. After a period of time, he did return to work on a full-time basis. However, he was not able to go back to the rigorous electric work that he had done in the past. But he still had to support his family. So he did continue working, albeit in more light type of work, and was not able to earn the same amount of money he was earning at the time of the accident. Because of that, we made a claim for his loss of earnings, meaning the difference between what he was making when the accident happened and how much he was able to earn after the accident. We also sought compensation for him for his pain and suffering that he endured as a result of the injuries to his neck and his back, as well as his left shoulder. Injuries that had impact on the way he was able to enjoy life, both as an individual, as a husband, and as a father. When we filed our action in the Bronx, which is where our client lived, we brought claims on his behalf for violation of Labor Law Section 240. Labor Law 240 is a statute which is designed to protect workers on construction accidents when they're working at elevated heights. The defendants argued that they were not responsible for the accident. In fact, they questioned whether the accident actually occurred because it was unwitnessed. Once we were able to establish that the accident did occur, they then tried to blame our client, saying that he was solely responsible for the accident because he was not using the ladder in a proper way. Fortunately, through hard work, we were able to prove that the defendants were in fact responsible. After the close of discovery, meaning once all the information was shared between the parties, we made a motion for summary judgment. We asked the court to find the defendants responsible for the happening of the accident for violating the labor law. We were successful. The court granted our motion and found that the defendants were responsible for the accident. The case was then scheduled for a damages-only trial, meaning the jury would determine what injuries our client sustained and what was fair and reasonable compensation for those injuries. In order to prove that the accident occurred the way in which our client stated, we obtained discovery from the defendants, including photographs of the accident scene, statements from a supervisor that was working at the job site on the day of the accident. And we also hired an expert to analyze the facts and determine that the ladder that he was given was not the appropriate safety device for the work he was doing at the time. Prior to trial, the defendants agreed to settle the case, and we obtained a settlement in the amount of $1,300,000 for our client. As a result of the compensation we were able to obtain for our client, he was able to take care of his family, pay his bills, pay for his children to go to college. While negotiating this case with the insurance carrier, they could not understand how our demand was so high and that we were not willing to settle the case for less than what we did. But ultimately, they understood, based on our experience and the way in which we handle cases and our willingness to go to trial, that we would never accept anything less than 100% compensation for our client. For that reason, ultimately, they decided to settle the case for the number that we asked for.